All right, we're ready now for WENWEI Sun versus Gilberto, AVILES, etc. Whenever you're ready, counsel.
Good morning. May it please the Court. My name is Pete Cardillo, and I represent the appellants WENWEI Sun, XIAOFEN Shu, and YUETIAN Sun. And I would request to reserve 5 minutes for rebuttal.
You got it.
Thank you, Your Honor. My client, Mr. Sun, was involved in an automobile accident over 10 years ago in Orlando, and he was rear-ended by a dump truck while parked on the side of the road with his emergency flashers on.
And there's no dispute in this case that all three of your clients purposely lied in their discovery, isn't that correct?
That's correct, Your Honor.
This is not a case of omission, inadvertence. This is a flat scheme by your three to hide the truth.
Well, I wouldn't call it a flat scheme. I don't agree with that characterization. But
A coordinated effort, since they all told the same false story.
They all told the same false story. That's
and they did
correct,
that repeatedly over years, correct? I mean,
over some period of time, intermittently. I don't know, in depositions and in interrogatory answers. That's correct, Your Honor.
If this ain't a sanction case, what is?
A sanction case would be, for instance, in the Cox case. And let me tell you why this. And when you ask about whether this is a sanction case, I assume you mean whether it should be a death penalty case. And I'll tell you why it's not. Because there was not a calculated scheme to interfere with the judicial system.
If all the three parties get together and come up with a false story to hide the truth, how is that not a calculated scheme to interfere with the judicial system?
Because it was not born of an intent to defraud the system, but it was born of an intent to protect my client, who was in a very difficult position. Judge Monaco in the Granados case, for instance, and here's what I think probably is troubling, would be troubling this court, would trouble the trial court. Certainly my reaction when I found out that my clients were being untruthful is that, hey, there's no dispute that they were untruthful, that they lied under oath. But that's not an automatic finding of fraud that requires...
What's the standard?
Pardon?
What's the standard the trial judge has to apply to this?
The standard is that the trial judge has to find by clear and convincing evidence, and this is a mouthful, but it comes from the Cox case and it's been repeated a number of times, that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability to impartially adjudicate a matter by improperly influencing the trier of fact or unfairly hampering the opposing party.
So what was the goal that your clients had?
The goal here was not to interfere with the judicial process. The goal was to protect Mr. Sun.
By?
I guess, go ahead.
By what? By doing what?
By ensuring that, and this is laid out in the only evidence upon which the trial court rendered its ruling, and so the only evidence that can be considered, as laid out in the affidavit, by ensuring that his employer in China would not be contacted, which would lead, my clients believed, to him losing this courtesy job that he had been given.
Well, I guess that could have been accomplished by not seeking any elements of damage that were relevant to that job, right? They could have not sued for lost wages. They could have not claimed that he was incapable of getting on a bus and going to work or whatever.
That's true. They could have. I mean, certainly they, and obviously I knew nothing about these circumstances, and they rely on their counsel to assert whatever claims that they're entitled to pursue. So I don't know that there was necessarily a connection on their part between what they were doing as a family and as a gut reaction to a very difficult situation and the claims that are asserted over here in the circuit court in Orange County.
I tell you, I have a big problem with your assertion that the trial judge has to accept as true their statement of internal intent, which of course, I mean, unless they wrote in the diary somewhere this we're intending something else, it'd be hard to impeach that after they've been lying to the court for a long period of time in a lot of different ways, in a lot of different forms, in deposition, under oath, and interrogatories. They're lying, they get caught, and yet it's your position that this is not a sanctions case because the trial judge had to believe them with respect to their subjective intent?
The judge had to accept the evidence with regard to...
The evidence was them saying, oh, we didn't do it for this reason, we did it for this reason. I don't know why the trial judge would have to accept anything that they had to say as truthful.
Well, the cases say that this is a very, very strict standard, and that's the evidence that was before the trial court.
The case law also says that a fact finder of fact can disregard even unrebutted testimony if he finds it not credible, correct?
Yes, Your Honor. I saw
the trial court
as
the finder of fact on this sanction issue could simply say, I don't believe what these people are saying, correct? Especially because they've admitted to lying throughout the proceeding.
I mean, literally from beginning to end.
I think the trial judge could reach that conclusion. I'm not sure that was expressed in any, either in a hearing or in the order, but I think that because of the high, what the court is troubled with is here's an instance of lying, just like in the Granados case that Judge Monaco, that you authored the opinion on, and in that case there was a recognition that the plaintiff had lied in an interrogatory answer, but the court reversed the trial court's dismissal there and said that even falseness is the word that Your Honor used, even falseness or falsity can be dealt with by impeachment at trial. And that's the same thing that this court...
There's a substantial difference in degree between Granados in this case, don't you think?
A substantial difference in degree between what, sir?
In degree of the quantity of falsehood that was dished out in each of the two cases.
Well, in that case there was lying in an interrogatory answer. There are other cases from this court that talk about for instance, the Gehrman case and the Ruiz cases, which talk about addressing even lying by way of impeachment at trial. So it is not as if, and believe me, when I learned of this, I had a pretty strong gut reaction to what had occurred, and there's no question that it's wrong. But what the cases say is that there's a zone where,
how wrong does it have to be?
Well, it has to.
These three people very clearly conspired to exaggerate the losses that were incurred.
That's no different than other cases that have been...
over a period of 4 or 5 years in virtually every discovery aspect of this case.
Well, I don't know if I wouldn't agree that it's virtually every aspect of this case, and it's not central. The other thing that is absolutely required, in addition to meeting that standard that I described earlier, is that it has to be central to the case. It has to be central to the claim. And this issue does not relate to liability.
How much were your clients claiming for lost wages, past and future?
It's in the brief. It's several $1 million.
So that's not central to the claim?
it is not central to the facts of the claim, is what I meant. In the cases that talk about centrality and this issue of whether it's central or not, distinguish does it relate to liability? Is somebody making misrepresentations with regard to whether the accident occurred or did not occur, or the light was red or
So
green?
in a case of clear liability, if you had a client, they had medical expenses, it was clear liability, but they didn't have any lost wage claim at all. They went right back to work. Under your theory, they could make a lost wage claim, they could lie through their teeth about it, and the only penalty if they get caught is, well, they don't get the lost wage claim, which they didn't have anyway.
Well, it would depend on the factual circumstances. If it was shown and proven from an evidentiary standpoint that it was a scheme, for instance, in the Brown case cited by the AVILES, decided by this court, where it was clear that the plaintiff in that case had constructed a wage claim that simply did not exist because he had not been employed, and that was the central part of the case. This court said, we're going to uphold. That's one of the few cases of affirmance of a dismissal because it was central to that claim and it met the standard of deceive and intentional deception.
I guess I also don't really understand your argument that the falsity is only related to a lost wage claim. I mean, the testimony that was false was that the injured party couldn't do anything by himself, had to have constant supervision, couldn't get on a bus, couldn't travel, that would affect the loss of consortium claim, it would affect non-economic damages, quality of life, absolutely everything in the damaged case. It seems like the fraud that they perpetrated was designed to do more than just affect the lost wage claim.
Well, the evidence is, and I can understand the court's inferences and there's some of the evidence that's been brought before the court in the answer brief should not have been brought because the surveillance evidence was not admitted by the court. So to the extent that some of that impression comes from that evidence, I would suggest that can't be considered. But I think it's fair to say that it could impact the life care plan as well. To what extent, we don't know, because we haven't gone through the process of revising that. So I agree. We have focused on the wage claim. I agree that it would likely impact the life care plan analysis as well. It would have obviously no impact on the medical expenses nor the non-economic damages aspects of the case, and I don't think it does.
Why wouldn't it affect non-economic damages if you have, in one scenario, a quality of life where someone can do nothing on their own, is completely dependent on others because of the physical limitations that they have as a result of an accident, and in reality that person gets up, does things on their own, takes walks, gets on a bus, goes into town, works. I mean, they have a very independent lifestyle. Why wouldn't that kind of difference be reflected in a non-economic quality of life kind of damage claim?
Well, yeah, I don't agree with those characterizations because those are extremes. There wasn't evidence that he couldn't do anything.
Wasn't the testimony a deposition from all three that he cannot do anything by himself? That he can't leave the house by himself?
That he could not be left alone.
He couldn't be left alone because he would start fires and was a danger to himself?
That's correct, Your Honor.
Yeah, and wasn't in reality the truth that he got on a bus every day by himself and went to work?
I don't know that that's the reality. I don't know that he went to work every day on a bus. I know that he has gone to work on a bus. That's what's been admitted in the affidavits.
But he's capable of independent living.
That's not evidence that he's capable of independent living because, just as a disabled person, there's no question he suffered a significant brain injury and that he's impaired. And certainly a disabled person, especially with the uniqueness of a brain injury, can accomplish certain functions and tasks. Doesn't mean they're capable of independent living. And there's absolutely no evidence of that. the key is, in addition to the court not having the evidence to make the finding that it did, is that the evidence that was presented to the court showed that my clients did this out of desperation and fear. His wages were all of $322 a month at this nominal job that he got because he was difficult to manage and because he needed a place to go. Alternatively, if the court believes that there was indeed sufficient evidence, the trial court should have considered lesser remedies, and that's what the Leroy case and most recently and cited supplementally to the court, the Hare cases tell us. And so in the alternative, we believe that the court should have considered lesser remedies. I'll defer to my colleague at this point, unless the panel has any further questions.
Thank you.
May it please the court, my name is Jerry Tolton, and I am here on behalf of the AVILES in this matter. Your Honors, I don't anticipate taking all of the 20 minutes, but let me just, I don't want to reiterate what this court has already suggested, but let me say this. In virtually all of the dismissal for fraud cases, not only out of this court, but all over the state of Florida, the issue really is whether there was a deliberate or sentient scheme set in motion designed to hamper the defendant, the defense, or commit a fraud on the court. Once that is established, the court has an arsenal of options at its disposal in order to deal with it. So it's a two-part test as I see it. In this case, the first part was established by the plaintiffs. It wasn't by the defendants. The plaintiffs came forward and said, we lied, we understood, we shouldn't have, but we've been lying since December 2002 or January 2003 or whenever the first deposition or interrogatory was propounded. We've been lying throughout the course of this, and here's our reason why. And once that was established by the plaintiffs, the court acted within its discretion. It could have done a number of things. It chose to dismiss the entire action with prejudice. And as this court has said in many cases, in many contexts, the appellate courts don't substitute their judgment for that of the trial judge. Judge Turner took a very serious and considered look at this case. And obviously, Your Honors, this was a very elaborate scheme. So I don't quite understand, I guess my point is, I don't quite even understand the appellant's point of error number one in their brief. Because I think what counsel is arguing is contradicted by his own clients, that there was error in terms of insufficiency of the evidence. Secondly, I don't want to pass on this because it's been mentioned in the briefs, it's been mentioned now in oral presentation, this notion of a nominal job or a courtesy job. And the court has already picked up on the fact that in the very same piece of evidence in which the plaintiffs confess their fabrication, they also say, but believe me now. But the more important thing here is that I keep hearing this number 322. He was only making $322 per month. Just a side note, and I will not elaborate on this, $322 per month in China is different than $322 in the United States of America. According to the Association of Asian Studies, a report came out in 2004.
Does the record reflect what his salary or income was before the accident at the same firm?
It's a great question, Your Honor. I honestly don't believe that it does. I know he was over here, he was at USF, he was a student. I believe he was working on his master's degree, perhaps, when this accident occurred. The accident happened, he recuperated, he went back to UCF for a couple of months, and then shortly after returning to China, he went back to work at his old employer.
Does the record reflect what a wage it would be in China for someone with this condition, or are you relying on non-record evidence?
I have to confess, I am relying on some internet research last night.
We should stick with the record.
Okay, all right. I knew I was probably going to get myself in trouble. And Judge Monaco, I just want to say specifically to the Granados case, obviously that was a case involving a plaintiff who misunderstood or didn't quite understand the nature of her medical history, but she tellingly provided her doctors in discovery. And this court said, wait a minute, that's not a deliberate scheme. It can't be a deliberate scheme when you provide the information that, the defense claims is missing. And again, I just want to reiterate also, this falsity relates to much more than lost wages, as Judge Lawson and Judge Palmer, you point out. It absolutely pervades every element: non-economic, pain and suffering, quality of life. This guy was presented to us as a complete vegetable, and I will candidly tell you, the trial lawyers in this case were scared to death. And the surveillance and the rest of the record that came out, and certainly the affidavits by the plaintiffs themselves, it was quite a shakeup for everybody, as you can imagine, after 7.5 years of litigation. If there's no questions for me, I'll go ahead and give my time over to the other side.
Thank you. Counsel, you have 4 minutes and 44 seconds.
Thank you, Your Honor, and I probably won't use that. Briefly on the Granados case, and also the circumstances in that case of the court attaching importance to the fact that I believe it was the doctor had been identified, and so the court believed that was of some significance. I respond to that very specific issue that it was not a secret that where my client was previously employed, and that had been revealed earlier in discovery. That is not by way of making any excuse for what my clients have done. With regard to the vegetable comment and the surveillance, first of all, the surveillance evidence is not before the court, and there's no evidence. And I think there may be a significant mischaracterization of the nature of a brain injury. It's not as if, and it was never contended, that my client was a vegetable, a term that I find somewhat offensive, but that he was significantly impaired by this injury. And if you ever met anybody with a brain injury, you can walk and talk, and it's very difficult to analyze. And so I don't think that it is as dramatic, and there hasn't been a change or any evidence of a change in that condition. There's no question that this conduct, when you see it, and when I heard it, and certainly when the trial court heard it, and I'm sure when this court saw it, there's a reaction. It's a normal reaction, and it's one of indignation and perhaps even outrage, because there's no question about the core event that occurred here. But ironically, unlike my clients who live in a repressive regime where something like this would probably have resulted in pretty swift and harsh punishment without due process, we, thank God, in our system do follow the rule of law, and do, however distasteful and however uncomfortable, to allow everyone, the worst of the worst criminals, people of the lowest status in our society, people who lie to protect their family members, everyone, access to our courts. That's a bedrock principle. And a trial on the merits of the case before a jury of their peers. And that's what my clients deserve, and that's all we are asking for. Thank you.
Thank you. All right, let's begin.